I do make that just on 7 o'clock. I was expecting a couple more people, but I think we'll just start anyway, because we did say 7 o'clock. So for those I haven't introduced myself to yet, my name is Trudy Craggs, and I'm a reporter with the Scottish Government's Planning and Environmental Appeals Division. This is a pre-inquiry meeting in relation to the following orders proposed to be made by Transport Scotland, acting on behalf of the Scottish Ministers. And the orders are the A720 Sheriffhall Roundabout Compulsory Purchase Order, the A720 Sheriffhall Roundabout Special Road Scheme, and the A720 Special Road Sheriffhall Roundabout Side Roads Order. Because there are objections to these orders which have not been withdrawn, a public inquiry will be held. I have been appointed by Scottish Ministers to consider the proposed orders and the objections to them, and to hold a public inquiry, and to submit a report to Scottish Ministers making findings in fact and recommending whether or not the orders should be made. Before we go any further, is everyone able to hear me quite clearly? Okay, that's good. Thank you. Here today is my colleague Callum Henderson, who is managing our sound and video recording systems. The meeting today is being webcast live to the internet. We introduced this as part of the Scottish Government strategy to enhance public accessibility to the planning and appeals process, and it makes it easier for individuals to keep up to date with proceedings if they can't attend. Generally, the public seating areas, not in the public seating areas, but the public seating areas were not directly filmed. However, by being here, you're consenting to being filmed and to the use and storage of those images and sound recordings, and any information pertaining to you contained in them, for webcasting and training purposes, and for the purpose of keeping historical records and making those records available to the public. To aid the webcast, please use the microphones in front of you to speak. Press the button once to switch on and again to switch off. The red light lights up and you'll know it's active at that point. If you need to move the microphone at every point, please lift it by the base and not the actual microphone itself. So before we just move on, just some housekeeping announcements. Can you ensure your mobile phones are switched off, if not already done so? As far as I'm aware, there are no scheduled fire alarms tonight, but in the event of fire, please exit the room by the door to the rear of the room, or that door over there, and we'll convene in the car park areas. Toilets are located outside the hall in the foyer where you came in. There is an attendance list, or a couple of attendance lists going around the room. Please can you ensure you put your name on that, name, organisation if you have an organisation, and an email address. And that's just so I have a note of who attended the meeting, and so I can circulate the note of the meeting afterwards. Finally, the seating is arranged with 1 metre distancing, purely for COVID reasons, so please do not move the seats around if you can help it. Thanks. Does anyone need a copy of the agenda before we start? Anyone else, or is everyone quite happy? Hi. I've just started by doing some introductions. So just to recap, this is the meeting for the Sheriffhall Roundabout scheme. Just to make sure you're in the right room. You're not here for the football and the darts next door. And just some housekeeping. If you can make sure that your phone's switched off, and if there is a fire, we'll exit the room either by the door where you came in or the door to my right. As I introduced myself, I am the reporter. I'm Trudy Craggs, and I'm the reporter with the Environmental Planning Appeals Division. So before we go any further, I've introduced myself, so I quite like to go around the tables and ask the parties to introduce themselves. I'll start with Transport Scotland, and then I'll just work my way around the room so we know who everyone is. So I'll start first here.
Thank you, ma'am. My name is Douglas Milne. I am a solicitor and partner with the firm of Morton Fraser, and I'm instructed for this public inquiry on behalf of Transport Scotland. To my right is Stuart Moffat of Transport Scotland, and there are other representatives of the promoter and their consultants, ACOM, sitting behind me.
Thank you. said before, you just press the button at the bottom and the light will light up and you just switch off again by pressing the same button.
David Mumford, individual objector from East Lothian.
I'm David French, representing Spokes, the Lothian Cycle Campaign.
I'm Mrs Margaret Clan. We stay very close to the Sheriffhall Roundabout, so this will have a big impact on us.
I'm Thomas Clan, the same, ditto. My name is Simon Capaldi. I live at Sheriffhall House, next to the Roundabout.
I'm Douglas Lowe, the farmer at Camp End.
My name is Claire Carr. I work for SWECO, and I've been advising Mr Lowe on transport matters for a number of years at Camp End.
Hello, my name is Rupert Nash. I'm an individual objector who lives in Musselburgh.
Hello, I'm Alexander Brett Walker, an individual objector living in East Lothian.
Thank you. It's nice to meet you all tonight. Moving on to item 3 of the agenda, just to set the scene for the purpose of the meeting, because I'm sure some of you have never been involved in a process like this before. I may be wondering what happens in the order of events, things like that. So to kind of demystify it, I thought we'd start off by just setting out the purpose of the meeting, and that's to discuss the procedural arrangements and the procedures to be followed during the inquiry and also in the lead up to the inquiry sessions or the oral sessions. And that's as set out in the circulated agenda. This meeting does not form part of the inquiry, so as such I'm not taking evidence tonight, and I'm not going to discuss the merits of the parties' cases at all. It is purely procedural. Sometimes that's hard to do because you want to get into your case and your issues, but today it's just the process. As far as the scope of the inquiry itself, matters relating to compensation are out with the scope. So I'm not here to adjudicate on compensation matters or accommodation works in lieu of compensation. That would be a different process if the orders are made and confirmed at that point in time. So that's not for this process. That's a separate process going forward. I'll be keeping a note of our discussions this evening as we go through, and I will circulate a note of that meeting and the points we discuss and agree as soon as possible, and that forms a procedure notice. And I'll say a bit more about that just at the end of the meeting, just to reiterate that point. So as I'm taking notes, as well as conducting the meeting, I may ask you to slow down when you're speaking. I may ask you to repeat something to make sure I've caught everything you're saying, just so I've got an accurate record. Obviously, it's webcast, which means I can go back and look at the recording itself, but I like to make sure my notes are as accurate as I can make them, so when it comes to doing the note of the meeting, it's very clear to me what we decided and what we discussed. Are there any questions on that? Was that quite clear to everyone? Okay, good. So item 4 on the agenda is about the process and the rules we follow as part of an inquiry under a CPO. So the orders are proposed to be made under the Road Scotland Act 1984, and so far as relating to the compulsory purchase, it's the Acquisition of Land Authorisation Procedure Scotland Act 1947. The relevant ministers are now the Scottish ministers, as these functions have been devolved under the Scotland Act. So if you're reading these acts, if you want to go and do that, references to Secretary of State in those acts should be read as Scottish ministers, but the acts still apply to what we're doing. There are no specific rules in place for inquiries into compulsory purchase of land by ministers. The compulsory purchase by public authorities Inquiries Procedure Scotland Rules 1998 apply to compulsory purchase by Scottish local authorities. And what we do is we apply these rules by analogy to provide clarity over the procedures to be followed, in this case with the orders promoted by Scottish ministers. There's also an associated circular explaining in plain English how the rules work, and that is Circular 17/1998. Now, I would advise, if you've not been part of a process, you may take time to read that, and what I'll do in the notes of the meeting is I will hyperlink to that, so it's easy for you to find, because sometimes it's difficult to find these things on the internet if you're just trying to search. So there will be a hyperlink, and it's Annex A and Annex D of that document that's probably of interest. Probably Annex A, which is the plain English guide to the rules. So item 5, there are, I understand it, 2,741 remaining objections to the scheme. And of those, my understanding is there are 17 statutory objectors, and I'm basing that on my understanding that Midlothian Council has withdrawn its objection. Is that correct? Okay. So 11 statutory objectors, and the difference is, for those who haven't been involved, a statutory objector is someone who land is being acquired, and a non-statutory objector is a third-party objector who's got an interest in the scheme, who are more than entitled to make an objection to it. But that is the distinction we have, and the distinction under the rules. So, for example, Mr. and Mrs. Clan, you're a statutory objector, and so are you, Mr. Capaldi, and so are you, Mr. Lowe, just to kind of set the difference. But I consider all the evidence before me, and I consider all the objections before me. There's not a difference on that basis. So I thought, just from the outset, from my perspective, it would be useful to have an update from Transport Scotland on the status of any negotiations that are ongoing with objectors, if they are still ongoing. There may be no update, and that's absolutely fine. It's just to make sure that I have the most up-to-date position going forward.
Thank you, ma'am. You're right, there isn't really an update by way of a change in the number of extant objections. However, Transport Scotland is continuing to discuss matters with a number of objectors with a view, if not to the withdrawal of further objections, to the narrowing of the issues. And, ma'am, your office will be kept up to date with progress which is made in that respect. There is perhaps one objector which is worth mentioning specifically, and that's Network Rail. It is, of course, they are not represented this evening. It is anticipated that this objection will be withdrawn, and discussions are also ongoing in that respect. I will, however, when we come to discuss further procedure, be asking for an inquiry session to be fixed to deal with Network Rail, just in case the objection is not withdrawn. Obviously, the promoter's position has to be safeguarded in that respect.
Thank you, that's really helpful. I was actually going to ask about Network Rail specifically, because I'm aware they're not represented here tonight, so that's very useful. And if you could keep our office informed of any withdrawals or any change in position, that would be really useful going forward. Okay, item 6 on the agenda. So a lot of these initial points are mostly for Transport Scotland, but I need to cover them off just for setting the scene going forward. So this is about the status of objections from Cala Management Limited and Shorefront LLP. And in a statement of case at paragraph 3.7, Transport Scotland suggested to me that these objections relate largely to the calculation of developer contributions to the cost of the proposed scheme, rather than objections as to whether the proposal itself should proceed. And they considered that the objections are not relevant for the consideration at the inquiry. Now, is that a fair summary of your position in your statement of case?
Yes, ma'am. If that's a fair reading of their objections, we're not entirely clear. It may be that what they're saying is that they have a concern about the amount of contributions that they're being required to pay.
Okay, I agree you could maybe read their objection in a couple of ways. I have read them and thought about it and what the objections were, and I actually thought, taking a wider view of the objection, given that it is made to the scheme, that their concerns really relate about the traffic modelling itself. Now, there may be downline consequences of that affects developer contributions, but I felt they had valid concerns in relation to the modelling, which I think you'll probably end up addressing anyway as part of evidence on the modelling. But I don't think at this point I can discount them or class them as irrelevant based on my understanding of what they're saying in their objections.
Yes, ma'am. The promoter is in agreement with that. I suppose the way to describe this is the promoter did wish to put down a marker that if an objection was founded in a concern about paying too much by way of developer contribution, that would be irrelevant. However, given that the objection is widely framed, it's certainly the promoter's intention to respond to the Cala and Shawfair objections on the basis that they are criticisms of the traffic modelling which has been undertaken, or perhaps queries about the traffic modelling which has been undertaken. So the intention is certainly to cover these points in evidence.
Okay, so the next matter on the agenda is alternatives to the proposed scheme. Now, Rule 6 of the 1998 rules deals with the process where a party suggests an alternative site for the purpose envisaged by the order. And the purpose of this order, or the compulsory purchase order, is improving and constructing a new grade separate junction at the Sheriffhall Roundabout. So being very clear about that, I know that some objectors have suggested alternatives, although not provided detail or specification, but having considered those alternatives, I don't consider that they are alternative proposals or alternative sites for the same purpose. So it's quite a narrow test in the regulations. So I've come to the conclusion that they are not alternative sites that are being put forward for the purpose of the scheme. They're actual alternative schemes. So it's focusing on, for example, active travel provision or non-motorised use provision, rather than having the roundabout, not per se looking at a different site for the scheme that's been brought forward. So there's a slight distinction there. Mr Lowe, I know you have proposed alternatives to the alignment of the A720 Mill Hill Road, and that's really to reduce the land take from you. And if you have looked at the agenda, I did think there'd be a separate session on that to look at those alternatives. Can I just confirm that in relation to those alternatives, I know that I think there's 6 or 7 on the table for the alignment, that no land would be required for another party to implement the alternatives you put forward, and really it's a matter of reducing the land take in plot 120.
Yes, that's correct.
And I know from Transport Scotland you've also looked at alternatives again. The case is it would just be a reduction of plot 120 rather than looking for land out with the order land.
That's correct. That's certainly always been our understanding of Mr Lowe's alternatives, reduction in land as opposed to alternative land. And ma'am, you'll have seen from our outline statement of case that we agree with the analysis that you've set out about whether NMU provision instead of the scheme is an alternative for the purposes of Rule 6, and as we've set out, our view is that it's not. But that's not to say that Transport Scotland wouldn't be responding to the requests, the suggestions which have been put forward by objectors in their evidence.
Yeah, I envisaged that things like that would be covered off in the session about design evolution, looking at alternatives, look at the NUM provision, things like that at that point. But we wouldn't need to go down the process in Rule 6 of notifying parties of an alternative. That's the kind of distinction I'm drawing at this point.
We're in agreement. Thank you, ma'am.
Okay, so now item 8, which is probably more of general interest as opposed to the few initial items I've discussed with Transport Scotland. So I set out in the agenda my provisional assessment of the main issues that I consider required to be addressed by the inquiry. And just to summarise those, mostly for the webcast, these are the need and economic case for the scheme, policy justification for the proposed scheme, including national, regional and local planning, transport and economic policies, design development of the proposed scheme, including proposed alternative to the scheme, which we just touched on, and including active travel, and that's with the exception of the alternative alignment to the A6106, which would be dealt with in a separate session. Traffic modelling, carbon greenhouse gas emissions modelling, environmental impacts of the scheme and proposed mitigation, and then be individual or site-specific objections, which would include the statutory objectors, and then a session discussed on Network Rail. So those are the issues that I felt that needed to be explored a bit more as part of this inquiry process. So really my first point is, are there any other issues that any party thinks I should be picking up? We'll go around the table just to make sure we're covering everything off. And what we tend to do is I will go around the table. Transport Scotland will have the last word because they are the promoter, but I will kind of conclude and sum that up. So I'll start with Transport Scotland and we'll move round and see if there's any other issues parties want me to pick up.
Thank you again, ma'am. That list of issues is appropriate in Transport Scotland's opinion, so I have nothing else to add at this point.
Yes, my concerns are also covered by that list.
Sarah, mine.
Same here, no other issues.
As agreed, as already stated. Yeah. Ditto.
We have no other issues.
No other issues.
Ma'am, could I just ask for some clarification on your first bullet point? Does that include the viability of the scheme, updated costs and the business case?
I'll ask Transport Scotland from their view, but from reading the objections, there are a considerable amount of objections about that. And there are a lot of objections about that, the cost of the scheme, the viability of the scheme, the financial justification of the scheme. I know it's linked to City Deal and things like that, but I feel it is an area that I need to explore given the cost of the scheme, to know that it is value for money. So mine, I anticipate that is an area that I would want evidence on.
Yes, the first bullet point does cover those issues. Yes, that's where the cost of the scheme will be considered and continue on into policy justification. So it will flow in that order.
So otherwise, I'm happy with the bullet points you've provided, ma'am. Ma'am, could I ask a question, please? It's not a cheeky question, but do you sit as an expert or an arbiter? Okay, it's just...
If you're asking what my background is...
No, just that in Lands Tribunal cases, the equivalent of the reporter is an expert. The distinction being that if you're an arbiter, you can only consider what's put before you. If you're an expert, you can use your own expert judgment, even though that perhaps a witness hasn't covered the point adequately.
I suppose we're a cross between the two maybe, so I will consider the case based on the evidence before me, but use my judgment when I consider that evidence based on my experience, which is a background in planning and transport law. So I don't go and look for evidence, I don't go and try and create a case for any party or establish a case. I will expect the parties to bring the evidence to me, and I can only consider the evidence that I have got before me, but I can obviously ask for evidence, which is what I'll do, and then I will write the report and make a recommendation to ministers. The final decision is the Scottish Minister's decision, and they can go against my recommendations with their own reasons for doing so. So I don't know if that answers the question or not.
Thank you, that answers my question, yeah.
And I wasn't being cheeky, you're quite entitled to ask. Okay, so that's helpful. So I think we've got an agreed list of issues that we want covered in the inquiry sessions, or the oral sessions, we'll say at this point. The next point in the agenda was about additional environmental information, and I wanted to raise that because given some of the grounds of objection, particularly around the traffic modelling and the carbon greenhouse gas emissions modelling, I just wondered if it was the intention of Transport Scotland to produce any additional environmental information, think about the environmental regulation rules and publication of an advertisement of additional information to respond to these matters. I just wanted to know what your thinking was based on the issues that we've highlighted.
Transport Scotland is content with the information which it has produced and which is available to the inquiry, but of course it is, well, as sort of an ongoing process of sensitivity testing is undergone in connection with schemes such as this, and of course the objections as they have been made and expanded upon in outlined statements of case are receiving careful consideration. So at this point in time, I'm not instructed to say that it is Transport Scotland's intention to provide supplementary environmental information, but as and when a final view is taken on that, ma'am, we will let your office know, because it might be appropriate to make a request of you in terms of Section 20, capital C of the 1984 Act. But as I say, that's receiving consideration. It's not a statement of our position that it is necessary this evening.
And just thinking about timing, when would you be in a position to confirm one way or the other? Because clearly, if there is a notification process, we need to go down that line, it may impact on timescales.
We would hope to be able to confirm the promoter's position by the end of this month, so as not to let matters drift on any longer than that. And I say the end of the month because the 1st of November is when I was going to propose that inquiry statements be produced, so that seems to be quite a neat time for matters to come together.
I mean, clearly the evidence you put forward to me is a matter for Transport Scotland. I would encourage you to try and reach a conclusion sooner rather than later. I appreciate we can possibly tie it in with dates for inquiry statements, but it would be helpful, I think, for everyone to know what the position was with additional further information.
Yes, I will confirm the position as soon as I am able to do so.
No, ma'am, I would find it most helpful to have an up-to-date report on that, because part of my concerns are precisely how far the proposals need to be assessed against what are current legislation and environmental demands.
And Transport Scotland will be aware of your concerns and your issues, and as part of this process they'll have to respond to those. So they're probably well aware of what your concerns are, and it is up to them to determine how best to deal with those. But I hear your point. Okay, turning to item 10, and this is about the participation and the structure of the hearing of evidence. And again, for those of you who haven't been involved, I just thought it was worth explaining what the options are for going forward if you haven't been involved in this type of process before you kind of think about where you want, how far you want to be involved and what your participation is likely to be. So I thought it would be worth outlining the options and what participation would entail. So those who have objected to a compulsory purchase order are entitled to be heard at an inquiry session, and that's what the regulations say, an inquiry session. But if parties are in agreement, I can opt to hold a hearing session, or I can deal with the matter by written submissions. So there are options there. I'll go through the differences so you can think about what that means. So if I hold an inquiry session, that means that each party taking part in that session is invited to present their evidence in turn, and then you're subject to cross-examination by those with opposing views. So, for example, Transport Scotland would start off, they would present its evidence, and they go through its witnesses. Each witness would give evidence in chief, which is they get to read their precognition and make some supplementary comments. Then every objector taking part in that session would be entitled to cross-examination of that witness, subject to the point by repetition of questioning, things like that. And that will continue through all our witnesses. Each witness will be cross-examined. At the end of the cross-examining of each witness, there's re-examination by Transport Scotland's solicitor, and then I get to ask questions. Well, I can ask questions at any point in the inquiry process, but generally we also ask questions at the end, after, so actually before re-examination, I would ask them questions, but I can ask throughout the cross-examination, and sometimes it's easier to do that when the topic's live as opposed to waiting to the end when it's out of context. But it is cross-examination, and then if you're taking part in that session, when you came to give your evidence, you would come up. Even if you're not represented, that's absolutely fine. You do not have to be represented legally. You would come up, give your evidence. If you're not represented, I would like you make some supplementary comments based on the evidence you'd heard already at the inquiry sessions. You would then go into cross-examination by Transport Scotland. I would then ask questions, and then I might give a chance maybe to make any final summing up comments as a re-examination at that point. But bear in mind, you are cross-examined by the opposing parties. So that's the kind of key point of the inquiry session. But you don't need to be represented to take part in an inquiry session. It's just a more formal process, and there is cross-examination. The other option, if parties agree, is that it would be a hearing session. So a hearing session is set up in a format like this. It's a roundtable discussion. I would lead the discussion rather than being cross-examination. So there's no formal leading of evidence, there's no setting out your case, there's no cross-examination. Parties can put questions to the other parties through me. It sounds a bit artificial, and generally what you do find is you do get into more discussion around the table. It's not so artificial as it sounds. I would set out an agenda, normally about 2 weeks before the hearing session. I make my hearing agendas pretty detailed and stipulate questions that I will ask. So parties have got time to prepare to deal with those questions. That doesn't mean that other questions can't come up or there wouldn't be supplementary questions, but it sets a detailed framework for those taking part in that session. Again, there's no need for legal representation. Lawyers can take part in the discussion, but there's no need for a lawyer as part of the process. It's more informal, and obviously because you don't have that cross-examination, it's more of a discursive situation than an adversarial situation. So that's the key difference between the two if you haven't been involved in either of those. And another option is written submissions, and it may be that some aspects of an objection could be dealt with by one process and other aspects could be dealt with by another process. So there's nothing to stop something being dealt with partly in a hearing and partly in written submissions, or partly in an inquiry session, partly in a hearing. So it's a bit of a mix and match, providing everyone agrees with the process going forward. And written submissions is, I would maybe pose a question or a series of questions that I wanted written evidence on. Parties would be asked to respond to that. You put your submission in, and then you get the chance to comment on other parties' submissions at that point too. So it's kind of a swapping of evidence, and you get a chance to comment on it. And there'll be no oral discussion on that. That's purely a written process. So is everyone clear about the differences in the processes, or are there any questions? Feel free to ask. No questions is a silly question, because if you've not been involved, you won't know what the process is like. I'm trying to demystify it so you feel comfortable coming and taking part in the process. So any questions, put your hand up, put your microphone on, and I'm happy to deal with anything.
Pardon me now. I mean, it's just guessing your head around it. So one of them is like a legal process with cross-questioning. Another is much more of a sort of participatory discussion with you there guiding and monitoring. And what's the third one? I mean, where people just put in written...
It would be written submissions if I requested written submissions, and we thought it could be dealt with through written submissions.
And it's possible to have part of the inquiry done one way and part of it done another?
Absolutely, and there will definitely be written submissions on certain aspects because some objectors are not taking part. Mm-hmm. And yes, we're quite able to do different parts in different ways.
Mm-hmm. Lovely.
I mean, the first process sounds quite legal, but you don't need to be represented to take part in an inquiry session. Often, I would opt for an inquiry session where the evidence is quite technical, so that other people are doing the cross-examination and experts are being tested. The hearing session it's led by me, and I pose all the questions. If you think about the process in each of these, whether it's an inquiry session or a hearing session or written submissions, what I'm trying to do is it's for me to get the evidence that I need. Like, I'm not trying to catch anyone out, not trying to trip anyone up. I'm not here to put people in the spotlight. I need to get the best evidence that I can get because I need to make that recommendation, and I need to kind of respond to all the objections and all the issues to ministers. So the ministers have all the evidence there and they can come to a decision on it. So it's for my benefit. So I've got to think about also how I can best get the evidence. So it's really thinking about what would work for people around the table and what would work for me as a reporter to know I can get the evidence. So that's why we kind of mix and match so we know we get the best process fit for the best topic. But clarify. But as I say, if we do an inquiry session, it's you're not precluded by taking part because you're not legally represented. Everyone can take part in it. So any other questions about just the process options? I know there's quite a lot to take in as we're going through. Okay, so we will discuss the topics and how we want to deal with the topics. We'll come on to that just in a moment. But having heard that, and before we come on to determine the actual procedure, does everyone still want to participate going forward? Have I put anyone off at all? That wasn't the intention at all. But I just want to make sure that now you understand what we're looking at and the process, and there's a lot of pre-inquiry processes we have to do, that you still want to take part. So if anyone doesn't want to take part, just raise your hands. If not, we'll assume you're all happy to continue and take part in the process. And it looks like you're all here for the long run, which is good. Now, as I've said, there are objectors who obviously aren't here tonight who want to maintain their objection, and they rest on their objection. And those objections I'll still consider. Some aspects of those objections naturally kind of cross with some of the aspects we'll discuss in oral sessions. So there is an overlap there. So whilst they're not here and they won't be taking part, there will still be oral evidence on some of the aspects of those objections, but I will still need to deal with them in my report to ministers, and they will just rest on their objections to date. So, based on the items in item 8 of the agenda, quite like to discuss now parties' views on the best way to deal with each of those topics. So what do we want to do for those topics? Do we feel it should be an inquiry, a hearing session, or do we think there are aspects that we could deal with by written submissions? Now, I would say, just at this point, while we're thinking about this, is that where parties are raising the same issues, or very common issues, I would encourage you to get together, group together, and present your case. Why I say that is not to preclude people taking part, but it's more the fact, one, it shares the workload, two, it avoids repetition, because there's no point for people asking the same questions one after the other, because we're not going to get anywhere. And I say it's for me to get the evidence. So if you have got similar issues, I would suggest you do kind of group together or share thoughts and ideas or have a spokesperson just to help you. And so it just makes the inquiry also more efficient. As I say, it's not to preclude anyone speaking or anyone taking part. It's just to make it more efficient. So just keep that in mind. And it does help kind of share the workload, because there's a few things you'll need to do if you're taking part in the inquiry and hearing sessions. There's also objections that are very specific to objectors, and we will deal with those in a separate session per objector. So don't think about you've got to kind of deal with an objector, but there may be things that you've raised in your objections which you think you might want to dovetail with another objector or another group of objectors when it comes to that topic. So I've also got my views on what I think, but I quite like to hear the parties' views. Now I'll discuss what the processes are. So I'll start with Transport Scotland, going through each of the 8 topics. If you can give me a view of how you think they should be dealt with.
Thank you, ma'am. Just by way of a sort of opening remark under this heading, there are a number of participants in the inquiry who did not produce outline statements of case. Now, I'm not wanting to take any point about that at all. The only observation that I would make is that Transport Scotland would reserve its position should any parties who have not produced an outline statement of case subsequently stray out with the scope of the objection that they've made, because Transport Scotland will be responding to the objections as they understand them to be. As regards further procedure, now we had attempted to set out under some topic headings in different sessions how matters would be dealt with and set that out in their outline statement of case. But since producing the outline statement of case, Transport Scotland now knows how many people are wanting to participate and has had the benefit of looking at the issues that each objector is wanting to raise. Transport Scotland has also taken into account inconvenience that would be caused to parties by saying you need to turn up at a number of different sessions. So with all of that in mind, the The promoter's view is that all of the bullet points, apart from the last two, which deal with site-specific issues in Network Rail, so the 6 bullet points under heading 8 could all be dealt with in one session, a single session which, given the technical issues which have been raised, and also given that each bullet point, as I said earlier, seems to morph into the following one, there's such overlap that it would all in all be easier to deal with all of those bullet points in one single inquiry session, which would have the benefit of cross-examination. Now, the promoter has got no desire at all for evidence to be heard on issues which are, on the whole, not particularly contentious. However, there are a lot of objectors who are not participating, and in order to make the evidence as helpful as possible to everybody, including to yourself, ma'am, what the promoter would intend to do is to produce one single report which deals with all of these 6 first bullet points and deals with those bullet points whether they are raised by parties who are participating in the inquiry session or not. Now, that's going to be quite a lengthy report, and as I say, we've got no desire for evidence to be led on matters which are not particularly controversial. But if parties take the approach, so Transport Scotland and all of the other participants, of their reports being their full evidence, but then precognitions when they are produced 2 weeks before the commencement of the inquiry are to respond to each other's reports on the issues which are contentious, then that, hopefully, will help to focus matters. It gives you, ma'am, the benefit of a report which covers everything, but then helps an inquiry session focus on the issues which are particularly contentious, raised by the parties who are wanting to come along for cross-examination, etc. We've started calling that the overarching session because I couldn't think of a better word, but it does deal with issues which are common to everybody.
I'll ask views in a minute. I agree there's quite a lot of overlap once you start looking at the various issues. It's quite artificial in some respects to curtail it into different sessions because they all do morph into one another, and one impacts on the other topics as you go forward. I suppose I'd be interested to know, from your view, the timing of that overarching report, and when you think you've produced that in evidence, given it is going to cover an awful lot of things and be quite detailed.
The timetable which I have been working to would be inquiry statements to give, obviously it's high level, but it's notice of the case which would be run at that session, none of which should come as a surprise to participants, because it will be largely based on written responses which have already been issued to letters of objection. But the report itself, given the work that it started, but the work that will be involved in finalising that would mean the end of the year. So my timetable is the 30th of December. I don't think it would be possible to produce it any earlier than that.
Okay, we come on to timing, but I'll just put a little flag up there that I think it would need to be produced sooner than that if we are looking at an inquiry late January, early February, because I think there'll be an awful lot of information in there for third parties to respond to. And given a Christmas period, New Year and everything else, I personally feel it's quite tight to give people a fair chance to comment on the contentious issues that are coming out of that, particularly if you do more modelling, for example, or scenario testing in the modelling, which may produce results that parties on the table and I haven't seen, which again, I just feel that might be a bit short to allow parties to comment on that. But we'll come on to the timing. So maybe parties will focus on the principle of what Transport Scotland have said, not the timing of it. And we can discuss timing at a later point in the agenda. So I'll just start here again. We'll go around the table.
Yes, I like that approach. Ma'am, I would support entirely your comments about the timescale, because hopefully the Transport Scotland report would update quite a number of the previous figures, and we would need time to absorb it and respond to it.
That approach sounds quite sensible to me. I wouldn't mind some clarification on the difference between, or what's envisaged as being controversial and non-controversial issues.
Yeah, I think it was contentious. So your precognition would make it clear which issues you were still in dispute on, which issues you still weren't happy with. And that would be the point of the precognition. So things that, when the report comes through, there might be things you think, oh, actually, I'm not going to press forward on my objection on that point, or I'm happy that deals with this. And then your precognition would home in on those points where you're still not satisfied with the position of Transport Scotland or the evidence you've seen, and that's where you would focus. So it's narrowing the point of focus so we're not dealing with issues that there's no dispute on, and we can deal with those issues where there are big issues that need to be discussed. So that's really the point of contention. Point. Does that make it clearer?
So far I found it quite informative. I don't know if you want to add anything to that.
Yeah, I think the point being that if the report is going to be fairly technical, then everyone would need time to digest that, and if need be, take reference elsewhere. So I think that would be useful to get a better idea. How long, once the report's been issued, would we have to for the next hearing and meeting to take place?
We'll come on to that, because we'll look at the timescale. But it's just kind of the principle. But from your perspective, because you've got, I suppose, a site-specific objection, there may be some things that come out of that general overarching session which you may want to come and listen to, and then take part in your own session. So maybe you'd have to attend two sessions.
So the hearing session could take place thereafter if it was client specific or site specific?
Absolutely. So what Transport Scotland's proposing is the first 6 bullet points, and not the site specific, would be dealt with by an inquiry session. And we can come on to the site specific ones just once we've had a discussion on this to decide how best to deal with those sessions. But that doesn't preclude you coming along to the inquiry session on the overarching issues. It's just we're saying that would be dealt with by an inquiry session, wrapping them all together because they're all so interrelated that one kind of knocks on into the other. So it's just really the principle. If that sounds reasonable to you, subject to discussion, timescales and things like that.
No, that sounds fine.
Ma'am, and if I may interrupt just while you're on that theme, Mr and Mrs Clan, of course, do raise some of the overarching issues in your objection as well, and I'd certainly be anticipating that overarching issues would be dealt with in the overarching session, leaving the site-specific session to deal with the site-specific issues.
Yeah, that would be my anticipation, that we wouldn't rehearse in the next session on a site-specific issue things we've already done in the overarching session, but it means you'd have to come to 2 sessions effectively to give you evidence on the overarching and then the site-specific.
I find it all very interesting so far. Nothing further to add, but what does the word precognition mean in relation to what my input would be?
Again, I'm going to come on to that, but I'll clarify, because it's one of these funny terms that I don't know where it really came from. Precognition is nothing more than a witness statement. So it's your evidence written in the first person, I, blah, blah. You would put maybe like a bit of background to yourself and then your evidence. And normally we could tailor it to about 2,000 words. which will come on to that. So it's no more than a statement, it's just given a fancy name.
So Mr Lowe's objection is purely site-specific, we haven't raised any issues around the overarching issues that you've just talked about, but I do think the timescale, which I think we're going to come on to discuss, is probably something that we would be interested in, but the objections remain purely site-specific.
Thank you, ma'am. So I have no objection to the process, except around the contentious decision. I mean, I trust that you'll be the decider of what's contentious, as you seem to have a good handle on this rather than the promoter.
Yes, at the end of the day I decide what I need to hear evidence on.
Okay.
And it might even be that, although maybe from the evidence, I may still, like, it looks like the parties are relatively happy or have reached a point where they're not pushing. I may still have questions on it.
Okay.
Because I need to satisfy myself when I come to recommendations to ministers. So yeah,
Okay.
at the end of the day, I'm led by the evidence, but ultimately I can still ask questions if I think something, to my mind, still seems to be a bit contentious, or I find I need a bit more evidence on it.
Okay. Thank you.
Yes, thanks to Mr Milne for offering to do this. I think that would be very, very helpful, and I'm happy with that. Yeah.
Okay, so in principle we're happy to do an overarching session for the first 6 bullet points. We'll come on to how long we think that session might take, but it sounds like we've got agreement on how that session should be dealt with. So turning to the site-specific issues, what are your thoughts on those?
Thank you, ma'am. In terms of site-specific, Mr Lowe, to start off with, given the technical nature of that objection, with the alternatives having been worked up to the level that they have, we would ask for an inquiry session to deal with that objection. But we do think it can be really quite focused. It is a focused objection. Timescales, I appreciate, we'll talk about in a minute, but we did think that would be possible to deal with in one day.
Okay, before we go on to the last, Mr Lowe and Ms Carr, for your views on that.
Yes, I mean, I think our view is that, given the technical nature, that it probably would be better dealt with through an inquiry session rather than written submissions or a hearing, because it is so focused. I would agree with the estimate of time, maybe even shorter than one day. We are still looking to discuss the objection with Transport Scotland with a view to finding some sort of resolution to that. So there's still very much a willingness to do that. But on the basis that it is maintained, then I think that's a reasonable assessment of the approach.
I would agree, it is technical, because every alternative is quite technical on the road standards and everything like that. So I think an inquiry session, will come to timing. I'd probably err on the side of caution and set aside a day, just to be sure, rather than curtailing ourselves too much. So I think we've got a position on Mr Lowe's objection of an inquiry session for a day. So Mr and Mrs Clan, do you have a view on that?
Yes, for Mr and Mrs Clan. Now, I'm not sure if Mr and Mrs Clan are intending to bring along any or lead evidence from any expert witnesses, but they do raise concerns regarding pollution, mitigation, noise, air, vibration, health impacts, which could potentially raise some technical issues. And on that basis, the promoter's position is that an inquiry session is appropriate for that, and again, hopefully could be dealt with within one day.
Mrs. Clan, what's your thoughts?
I think we would bring in some experts pertaining to those elements, because we're not experts, so we would have some professionals along with us to discuss those. So I think that sounds reasonable.
And so you'd be happy with an inquiry session where those experts would kind of give evidence on your behalf and they'd be cross-examined?
Well, I would inquire, or a hearing session, because I think these are issues that could be brought out, discussed. I don't believe it would involve an inquiry session, but if that's a preferred choice, then so be it. We don't mind. From what you were saying, I'm led to believe that the inquiry and the hearing sessions can overlap. If there's issues that can't be resolved, can go into another hearing or whatever. Is it not? I don't know.
I'm not here to resolve the issues per se. It may be through the course of discussion you get to the point where you get close to it or things become more obvious, but I'm not here to resolve the objection or to mediate or anything like that. I'm just trying to get the best evidence I can to decide whether the order should be made or not, based on the objections that are before me.
Well, let's leave it at the inquiry then. Yeah, that's fine.
Yeah, so if we set an inquiry, then we'd stick to the inquiry on your objection. We wouldn't chop and change during the format, because the lead up to that session is different depending if it's a hearing or an inquiry session.
Sure. Okay.
But I hear what you're saying about the hearing session. What I'll do is I'll go into now look at your objection, and I'll think again whether it would naturally be a hearing or inquiry, noting you've got no objection to an inquiry session. Given there are some technical issues like noise, vibration, pollution, and you have experts, it would tend to push me towards having an inquiry session because they're more technical in nature. But I will confirm that in the note of this meeting. I would probably agree that 1 day is probably enough again to cover the issues.
Some of the figures have been quoted by the ACOM team on pollution, etc., etc. So some of those have been discussed, but I haven't had the opportunity to discuss it with our people to see what their thoughts are.
Absolutely, and it may be you discuss it with your people and they'll be the ones that cross-examine.
Sure.
And the ones to be cross-examined. Or it may be that by speaking to your experts, you get to the point where you narrow down the issues, and there might be some points we think, actually we now are not going to maintain that point of objection, but we want to maintain these aspects of it. And that may come out as you discuss with your experts.
Sure.
And that's kind of the point of this process, is trying to narrow down the issues, but I'm not here to try and resolve it. I'm here just to hear the evidence and reach a conclusion for ministers.
Okay, your comment.
Okay. Mr. Milne for Mr. Capaldi. Your thoughts on that one?
Thank you, ma'am. For Mr. Capaldi and Ms. Page, now, I would be grateful if Mr. Capaldi could confirm to you, ma'am, whether he is intending to bring any expert professional witnesses, or if he has, or Ms. Page has any professional expertise themselves, because in the absence, given the nature of the objection, but given what I understand to be the absence of a professional team, the promoter would be content to discuss that objection at a hearing session.
Mr. Capaldi.
At the moment, our objection is purely site-specific. We don't have any legal representative at the moment. It's not something I've given a great deal of thought to, but perhaps it's something I should look into. And I'll get back to you on that.
It may be you don't need a legal representative, you might need another form of expert to give evidence on aspects of your objection.
Same reply. I haven't really got that far in looking into that. We haven't, at the moment, taken legal advice.
I wonder, ma'am, if we could fix an inquiry session just to start at that level. But if Mr. Capaldi does, following further consideration, decide that you wouldn't be bringing any an expert team, we could downgrade to a hearing session, but the promoter wouldn't want to end up almost by default at a hearing session with potentially complex evidence being discussed, because I don't think that would be satisfactory.
Would you be happy with that, Mr. Capaldi, if we went forward on the basis of an inquiry session, and if you feel that you're not going to bring any experts, you just want to present your case, which you're entitled to do, then we could have a hearing session, if that makes it easier to have a round table discussion?
Yes, I agree with that.
Okay, so it looks like we'd have an overarching inquiry session, and then we'd have possibly 3 site-specific inquiry sessions for the statutory objectors, and we'd set time for another inquiry session for Network Rail on the basis that objection is not withdrawn at that point in time. Okay, so we've discussed the site-specific ones. We probably think 1 day for each objector, which seems reasonable. The overarching session, there's quite a lot in that session that would need to be covered. There's obviously a lot of issues in dispute, a lot of points of contention on there. I don't know how many witnesses you'd want to lead at this point in time. I don't know how many witnesses others would want to lead at this point in time. I suppose, how long do you think the evidence would take an inquiry session for the overarching session?
Our thinking is that the overarching session could comfortably fit within 4 days.
Based on my timeline for the various bullet points, I'd got to about 4 or 5 days.
It depends how much we can narrow down in the meantime following the report that Mr Milne has promised. I think we're talking about a week. But then again, I mean, one of the big contentions is the greenhouse gas emission calculations, for example. Now that could take some considerable time. Andy Anderson and policy compliance and need, there's a lot in that. There's a lot of documents, there's a lot of contention there. Zoe McClelland on national and local planning, there's a fair bit there. Plus she's going to be dealing with the EIA and the environmental mitigation. Again, there's a lot there. There's the modelling, which is at the moment is very contentious, but that may fade a bit if we could get some consensus. I mean, Spokes' objection, I've read it, and obviously that will take a bit of time. Then there's various, which I don't think I think could maybe even be done by written exchanges. There's the noise impact, the agricultural impact, the air quality, except for the greenhouse gas emissions. The social economics, again, that there needs to be a lot of clarification there, I feel, and social inclusion and equality, but that might come out in the report that's to follow. I mean, then there's the evidence in chief, and obviously it looks as if we could probably pull that in with maybe one person leading the evidence, or not leading it, that's not the right word, but providing the evidence.
Yeah, so one person always leading for a group
for
and asking the questions.
Exactly.
Like that, yeah.
And then maybe someone with a knowledge of modelling could lead on that, and then of course possibly the spokes could speak to the active travel issues. Something along those lines, but I mean, just to give you an example, I read my own sort of outline submission with a wee bit of addition, and it came to 1.5 hours. I'm sorry about that, but it did. So that gives you an idea of timescale, and as I say, there's a lot, for example, in the policy that we're really at loggerheads on at the moment, complete different interpretations of certain national policy and local plans and things like that. And I think that could be a number of hours in cross-examination, except we don't have a solicitor, but never mind.
Don't let that put you off. You're quite entitled to have different people leading the cross-examination for different witnesses. That's absolutely fine, because you're right, you might have a transport modeller who want to come along and do that aspect of it when their witness is giving their evidence. There's no issue with that having, just because they've got, obviously, Mr. Willen, who will be doing the cross-examination, you can use your team how you want to use your team. How you want to use your team, particularly if you've kind of put together to avoid the repetition. I mean, I don't want everyone kind of one after the other asking similar questions, because that's not going to achieve anything. But you're quite entitled to do that.
And just to let you know, because the greenhouse gas emissions is so contentious, we might actually try to get an expert on greenhouse gas emissions. Oh, sorry, we will try to get her. Whether we get one or not, I don't know, but we will try.
Mr. Mullins, do you want to comment?
Now, Mr. Walker, of course, with a submission which takes an hour and a half to read, may not have to read it out, because if that's your evidence in chief, so that may save some time. But perhaps what we should do then, if ma'am and parties are in agreement, is take the full 5 days of the week rather than the usual 4 days, just to guard against an overrun and running out of time.
I'd rather err on the side of caution, because there's nothing worse, as you know, when you get 9/10 of the way through the inquiry, we don't quite finish it off. And based on the fact there would be 3 days for site-specific objectors plus Network Rail, I'm just wondering whether we actually set 2 5-day weeks. Historically, what happens in inquiry sessions is we start on a Tuesday. Again, that's just a historic thing. I don't actually know why we did that to us, but that's history. We always started on a Tuesday and ran 4 days a week and didn't sit on a Monday. There's nothing to stop us sitting on a Monday. I'm quite happy to sit and do inquiry sessions on a Monday. It makes no difference to me. But if we had 2 weeks set aside of 5 days each week, that would mean having 3 days for the objectors, we'd have potentially 6, if not 7 days to do the overarching session on the assumption Network Rail inquiry session isn't required, and still have ample time to deal with each of the site-specific issues and have sufficient kind of bunts in there to make sure we can deal with all the issues on the overarching session. And if it takes 5 days, we just wouldn't sit the next Monday. I mean, it just means we've got the flexibility. I'm not asking people to pad out the evidence to last the 7 days. If we do it in 5 days, that's absolutely fine too. But I don't want the situation where we could do with 5.5 days and we've got to try and reconvene another half day at some point, because that gets pretty difficult. So that would kind of be what I'm thinking is the 2 5-day weeks. And we'll come on to which weeks those should be. Would that generally suit people? We can come on to the actual dates, but I just feel there's nothing worse than not quite finishing it. It doesn't do anyone much good to have to try and find dates in March or April when people's diaries are kind of booked up at that point. So does that sound like a reasonable solution at this point? Okay. Right, so I'm trying to do this almost back to front, just to flag the dates I was thinking of, and we can look at that when we look at dates for submissions, but just to think in your minds at the moment. I was thinking of proposing a start date of either the 24th of January or the 31st of January for 2 weeks. So it'd either be week beginning the 24th, week beginning the 31st, or week beginning the 31st, and then that first week in February for the 2 weeks. We can firm up on that when I go through what needs to be done before you get to the inquiry sessions, because there's obviously a lead-in where you have to disclose your positions and your evidence. So if we bear those dates in our minds at the moment, and we'll work towards them and see what date works better, because we've also got the Christmas and New Year periods, and we've got this report coming from Transport Scotland to factor in the timeline too. Is everyone available for those 2 weeks? Yes, round the table.
Maybe not in Burns Day, a Burns night.
Is that the week commencing the 23rd of January?
24th I think is probably the Tuesday, but yeah, the week being the 23rd and the week after that being the 30th.
I'm afraid I'm lecturing that week, so I will be required to be in front of a room full of students.
Would you be teaming up with others who'd be able to present?
Likely, yes. Mr. Alexander and Mumford, certainly. So,
I don't want to feel you haven't had your chance, but I need to obviously progress the inquiry as efficiently as I can. So if you felt you were presenting your case as a group, do you lecture full time? So you don't have to tell me that bit.
yes, but I can shift some weeks, but not that one.
Based on the fact that everyone can do the 2 weeks, would you be happy for us to proceed with those weeks?
Yeah, of course.
I mean, it might be we slip it by a week. Anyway, just factoring the timeline and the report and giving people a chance to speak to that. So we'll come back to that point, but I know...
I have some flexibility about these things, but...
no, I appreciate that.
I'm only one out of many, and...
I know, I'm not trying to preclude you, but we'll look at that, because I have said I will start that week or the week after, so maybe we'll push it to the week after. It depends on the timing of the report and factoring in time for parties to respond to that. So we'll come back to that, but I note that you're not available that week.
Ma'am, the promoter's preference, I appreciate this is because of what you're about to discuss, and the lead-in would be to have the inquiry starting on Monday 30th January, so to have those 2 weeks, the 30th and what's that, the week of the 6th of February. But that's actually just to allow a proper length of time for the preparation of recognitions in light of the Christmas break.
I think we'll probably get to the later dates, to be honest, just to factor in the time, so your unavailability will not should be an issue at all. But we'll come back to that. We can confirm at the end when I've gone through the next part of the process. So before we go on to the timeline for disclosures, before the inquiry starts, a venue, at this point in time there's nothing to prevent us doing an in-person inquiry. Clearly, if there are any differences to the COVID rates at any point, government may take a view on whether we can do in-person inquiries. We have done virtual inquiries online, so we can keep going, but we'll assume at this point it's an in-person inquiry because there's nothing to stop us doing that. And there could be quite a lot of people and experts around the table, so we need to factor that in. But at this point in time, let's assume it's in person. we need to find a venue. Obviously, we've got here's a venue. We can also look at other venues. I think you gave us some options previously. Has anyone got any thoughts on a venue? Is everyone generally happy to be in the Dalkeith area for inquiry? We've got to find a venue that's large enough, accessible, things we've got to kind of tick. But if you're happy with this general area for an inquiry, then we'll look at different venues and this venue too for availability for the weeks we need. Is that okay for everyone? Okay, so we'll look for venues, and I will confirm that. Perhaps not in the note of the meeting, because it will come out quite quickly. So there might be a follow-up to confirm the venue once we've checked availability. We've just got to go through various process to make sure it's fit for our purpose. What generally happens is on the first day, so the Monday, is the session will start at 10 o'clock, and then on subsequent days we start at 9:30. And we generally sit until about 4:30, 5 o'clock. I would naturally break it at a point in the evidence where there is a natural break, rather than stopping someone mid-flow. There's short breaks in the morning and the afternoon, and we break for about an hour for lunch during the course of the day, wherever is a convenient gap in the proceedings. We would anticipate webcasting the proceedings live, again, because people might want to watch it. Or if someone's not available on a certain day, they can watch it afterwards from our webcast library. So it just makes it more accessible again. But again, it would confirm that before the inquiry sessions, but assume we were anticipating we would webcast it. In the same way as we're doing today, it just need microphones. You can become unaware you need microphones, but we've just webcast it just so it's more accessible. So just move on to item 12 on the agenda, just the prior disclosure of cases. And this is thinking about the timeline and the exchanges we need to take place before we actually get to the inquiry session. So that's kind of the end point, and there's a few things happen before that. So the first thing we've kind of touched on is before the inquiry session, we need an inquiry statement. Now, some of you have produced outline statements of case. So this is really, you pull together an overarching statement setting out the case you intend to put forward. So it's not going to the details evidence, it's still quite high level, but it's giving, particularly Transport Scotland, notice of the points you're going to make in your evidence, the issues you're going to cover. Think about what your objection was. You can expand it a little bit based on your objections, but it's giving everyone fair notice of what your evidence and your position is going to be when it comes to the inquiry session. You'd specify in that any witnesses you're bringing to the inquiry. So again, we know who's kind of taking part, timescales, things like that. You can highlight who you think will be presenting your case, and there might be different people for different aspects. And you would set out a list of documents in this statement too. Now that doesn't preclude you submitting other documents at the point we submit documents, but again, it's the whole point is to give people fair notice of what's coming. That's kind of the whole ethos behind this. So it's being transparent, being open about your cases and your position. And I had actually thought that they would be produced by the 1st of November, which is 4 weeks from today. So that's the first date that I'm thinking of. We'll come back and discuss these, but that would be the first date, be the 1st of November. Now, I was really thinking that all documents that you want to rely on, all the parties want to rely on, so that would be any expert evidence reports, photographs, plans that you've got, drawings, anything that you're going to rely on in your evidence has to be produced before you put your written statement or your precognition in. And I was thinking that these, and this would include Transport Scotland's overarching report, would be submitted by the 20th of December. And this is going to be an idea of my thinking, which is before Christmas, so people get it for Christmas. I'm not asking you to work over Christmas or look at it, but I just thought possibly it was better at that point in the process. That would be the 20th of December. And then what happens is working backwards from the inquiry date for precognitions. If we were starting on the 30th of January, the precognitions or your witness statement is 2 weeks before that, and that would be then the 16th of January. So that's giving parties I suppose, a month, albeit you've got Christmas and New Year in there, to produce their written evidence based on the report you'd get from Transport Scotland. And that would naturally push the inquiry dates back to the 30th of January, which would fit with your availability. The witness statement, or the precognition, which is your statement of evidence, we generally say should be no more than 2,000 words. And the reason for that is to try and get any reports in which should encompass most of the evidence as a document rather than as your witness statement. If it's more than 2,000 words, there would need to be a summary document also produced at that point in time.
Sorry, just a second. What was the 1st of November date? Did you mention?
The 1st of November is your inquiry statement. So it is, if you'll see in Transport Scotland's outline statement of case. So it's quite similar to that. It's setting out your evidence, the evidence you're going to lead. So it's giving Transport Scotland an indication of the points you're going to make, what your case is, not setting out the detailed evidence, but just what your evidence is going to demonstrate. So it gives them notice of your position on various aspects of your objection. You would list in there any witnesses you're going to bring and your list of documents you want to rely on. Now, that doesn't preclude you lodging a new document or an additional document when the documents have to be lodged in December. It just gives a guide at this point, insofar as you can be, pretty certain at this point what documents you want to rely on. But it may be you add 2 or 3 more at the point you're actually submitting documents, which is fine. But again, it's about giving Transport Scotland notice of what you're relying on, the case you're making. That's kind of the whole kind of point of doing this. So if you have a look at their statement of case, that'll kind of show you how detailed it is and the things they focus on. And you do the same from your perspective of your objection, your site-specific issues. Okay. And then you lodge your documents, and then your final document is your witness statement, which is your evidence, your written evidence, fleshing out what your statement of case said. What I'll do in the note of the meeting actually is I'll give a link to, we've got guidance on, it's more planning appeals, but that might give you an indication of, or more detail about the expectation of inquiry statements and things like that. So I'll see if that's if it's helpful. I'll put a link in just so you can maybe look at that. If it gives you more detail, if I don't think it's going to be helpful, I won't bother, because there's quite a lot of other documents to look at. But if I think it would just give you more of a steer, I'll give you a link to that too in the note of the meeting. Okay, so thinking of that as a timeline, I'll ask Mr. Mill first from Transport Scotland's perspective, because it kind of hangs on this report and the timescales for that report, to make sure everyone's got ample opportunity to respond and have time to consider that.
Thank you, Ma'am. Yes, those dates are all fine insofar as Transport Scotland is concerned, and to bring, I was going to propose, as I'd mentioned, documents including reports by the 30th, but bringing that forward to the 20th is fine. We were also going to suggest hearing statements, which currently might not be required. Fine.
Yeah, I'm working on the assumption no hearing statements.
And written submissions for site-specific objectors who would not otherwise be covered by the materials we've discussed to date. For example, the Buccleuch group of companies. We would just lodge at the same time as all of the other, they may not be technically documents, but suggest we just lodge them on the 20th as well. So, sorry, I'm straying off into other procedures, but those dates are fine.
Okay, that's fine. I'm assuming no hearing statements on the basis of doing inquiry sessions. I'd be happy with the written submissions coming at the same time as documents. From my perspective, that would work fine for me. So, again, I'll go around the table, just getting confused as to whether that timeline seems workable from everyone's perspectives. Everyone relatively happy with that? Okay, this will all be set out in the note of the meeting, so don't worry about if you haven't taken notes or captured everything. I will set it all out in that document. Okay, so item 13 is about other submissions. So the first point in there is about legal submissions. And the reason I flagged this was from looking at the objections and the outline statements of case that I've got, I thought there was probably two issues in respect that I would benefit from further clarification and information on. And I flagged both those points in the agenda. The first one is whether the proposed scheme would be in contravention of the Climate Change Scotland Act and the Climate Change Plan Update. And that was, I drew that out of the outline statement as a case and the comments from the parties on the table actually about whether it would be in contravention. I've classed this as a legal issue because obviously it's an act and there's legal things in the act. And I just felt that I would like just more information on that from both promoter and the third parties who have raised concerns about that. I felt it was something that could be dealt with in written submissions. What might happen is we have written submissions and it may be I have a question at the inquiry session about it, if I still felt there was something that I wasn't quite sure on. But I felt as a starting point it might be that I get enough information from the written submissions that I know the position I would take on it. So looking at the outline statements of the case, I felt the parties I'd ask this information from, I would set it out in the notice of meeting, would be obviously Transport Scotland, Mr Walker, Mr Mumford and Mr Nash. But I don't know if you want to do a joint submission together, which again would be absolutely fine. There were a few other third parties who actually raised it who are not here tonight, who indicated they want to participate, so they would be asked to. And what would happen is, I would set out in the notice of the meeting the information I want. You would submit your written submissions at kind of exchange, and then get an opportunity to comment on the other parties' submissions at that point. Generally, I'm thinking a timeline, I would probably factor in the submissions for something like the 1st November again. I don't mind if that needs to go out a little bit because there is a bit of room in the process, and then you would get 14 days to comment on the other parties' submissions. So that's how that process would work. Now, if parties feel the 1st November would be difficult because you've already got the inquiry statements to work on, I'm happy to push that date out further into November, even by a couple of weeks, if that would just give parties a bit more flexibility to deal with that issue.
Ma'am, if we could see inquiry statements first and then produce the legal submissions just so that we know what cases are being argued by each of the parties and the parties know what Transport Scotland's position is. So perhaps written submissions on legal matters middle of November, the 14th, if that's a day of the week, not the weekend, and responses 14 days thereafter.
I'd be happy with that.
Yes, that sounds. I presume we will see the legal opinion.
Yes, you will. So whether you class it as legal opinion or legal submission.
Or legal submission, yeah.
So yes, so initially you would prepare your own submission based on what I want the written submission on, because you've made statements in your outline case about it being possible contravention of the Act. So you would write your submission, you would then submit it to me through the office and the case officer, as you've done with your outline statements. And Transport Scotland have got an opportunity to comment on that, and you'd get Transport Scotland's submission, and you get an opportunity to comment on that. So you'd have 14 days once you've had sight of that to produce a response to it, in effect. So I have submissions from both parties, and I have their comments on the other parties' submissions before me. That's the evidence I would have on that topic.
That's fine. I could venture as well that we might be able to help a little bit further in as much as Danny White, one of the objectors, was spoken to him, and he couldn't be here tonight, but he's happy to join our band. as well as Dr. Shona. So that's 5, at least, we can amalgamate.
That'd be great, because they were down on my list as parties who had raised this as an issue. So yeah, you could all put a joint submission, and that's absolutely fine.
Sorry, could I sort of make a point? I mean, certainly from my point of view, the possible contravention of the Act flows from the scheme's modelling and justification. So any updates to that would have a very strong bearing on any case I might like to argue. So in some sense, I'd like to see any updates to the promoters' modelling and so on before making the argument, if you see what I mean.
So you prefer to do a written submission after you've seen this overarching report and on the subject it deals with some of the issues you're concerned about?
That would be my preference, but of course it's your decision.
Would it then be sensible for the legal argument to be with the closing submissions, so as it benefits, parties' submissions benefit from having heard all of the evidence?
That would be my view, but I can't speak for the others on that point. It just occurred to me as we were discussing the updates to the modelling, etc.
I have no issue with it being part of a closing submission if parties feel that's a more appropriate point in the process to do it. It doesn't preclude you dealing with the modelling and the greenhouse gas issues as part of the inquiry session, which might inform your position on the legal point anyway, so I'm happy to do it as part of a closing submission which should follow the inquiry sessions. And clearly I would give you a period of time to do that. It won't be on the hoof, I'll give you a point of time when we agree that. We agree it now, but I give you sufficient time to do that. And Transport Scotland, I suppose the difference would be is that if you do it as part of your legal submission, your closing submission, Transport Scotland responds to it and makes legal submission, but you wouldn't respond necessarily to Transport Scotland's legal submission unless at that point we called it a written submission process and we go through an exchange of submissions. But ordinarily you submit your closing submission with your legal submission. It's Transport Scotland as the promoter who gets the last word in that, who would comment on it as opposed to you commenting on their position. So that's the kind of difference in the process at that point in time.
Yeah, I'm slightly worried, but I would go along with that. Ma'am, are you appointing the counsel to give legal opinion?
No, it's not a legal opinion.
I said the legal...
I'm just asking for clarification on the point, which is quite a legal point, that the scheme being contravention of the Act. And I call it a legal submission because it's based on an Act, based on legislation. I'm not appointing QC or counsel or anything like that. Obviously, Mr. Mullen is a solicitor. I don't know if he'll produce it or some of the team will produce it, but because it's based on an Act of Parliament, I feel it's a quasi-legal point. What would happen is that it would be factored into my report, and Scottish ministers may determine at that point that they would get legal advice on it before they reach their decision on it. Or I may recommend in my report that they should get some legal advice on it before they reach a final decision on the orders. So that's the kind of sequence of events. But I wouldn't engage counsel or get a legal opinion from my perspective. I pass that to ministers because they're the decision maker based on what I've heard. Does that clarify?
Yes.
You'd be entitled to go and instruct someone on your behalf to do the written submission, and Mr. Mullen could do it. He could instruct a QC. It's up to you how you present your legal submission at that point in time, but it's not for me to recommend what you do to produce the evidence for me. So would you be happy to do that as part of your closing submission?
Yeah.
Okay. And then you would do it as part of your closing submission? Just factoring that in, I would probably then be slightly more generous on the timescales for closing submissions, just because it's not necessarily just wrapping up all the evidence, it's actually dealing with that point as well, but we can come on to that. Okay, the second issue that came up was whether the proposed scheme would comply with duties under the Qualities Act 2010. And again, I pulled this out of the outline statements of case, and again it's whether you feel that that is again something that would benefit from hearing the evidence before you come to a position on whether you think it complies or otherwise with the Qualities Act.
I guess I have the same opinion about this as the climate change case, so yeah.
And again, subject to what Mr Mill might think, I'd be happy to wrap that up also in the closing submission and give Transport Scotland an opportunity to comment on that once you've heard the evidence.
I think it makes sense for all legal issues to be dealt with at the same time, and therefore in the closing submission procedure.
Okay, I'm happy with that. That we'll do that as part of the closing submissions. I would stress if anything else comes up that you feel you want to make a legal submission on, that if may affect the running of the inquiry, please do it sooner rather than later. There's nothing worse than getting far down the line in the inquiry process and a legal issue comes up, which means we've got to change the course of what we're doing. So don't wait to the start of the proceedings, raise it, submit it as part through the DPA with the case officer. Just delaying doing that is kind of contrary to the spirit of the whole inquiry process. So closing submissions, they are done at the close of the inquiry. We do them in writing. You're not asked to kind of do it on the hoof on the spot at the end of the session. You do it in writing, and again, it's the objectors would submit theirs first, and then Transport Scotland submit theirs a few days later. Generally, we discuss the timings at the end of the inquiry session, which we can do, and we can factor in time for legal submissions. But based on that, I'm probably thinking, and I know the school holiday week, the week after we would probably finish. We're probably looking at like 14 days for closing submissions, but we can discuss and agree that at the end of the inquiry session. And for each of the site-specific inquiries, you would do a closing submission again in writing. And really, what it does, it kind of draws your whole case together. It's no new evidence. It's not about presenting any new evidence or anything you haven't presented to the inquiry. It's pulling your case together, pulling all your strands of evidence together, and kind of telling me what I should take from that evidence. So that's the point of the closing submission. It doesn't need to be very long, it can be as long as you need it to be, but it's just summarising your case and your final position, having heard all the evidence at the inquiry session. So it's what I would take away from it based on your positions. But we can agree that at the end of the inquiry session. And just a final point in relation to claims for expenses, that I will put a link in the note of the meeting to the circular, which is Circular 6 of 1990, which deals with awards and expenses for compulsory purchase inquiries. So I'll flag that up with a link to it if you want to have a look at that too. Right. Item 14, site inspections. So obviously I'm fairly familiar with Sheriffhall Roundabout. I kind of know what it is. I've been around it several times. Obviously not looking at perspective, I need to look at it now. So it's really, I'm thinking, I was going to go and see the roundabout, and I also feel it would be beneficial for me to see other specific locations. I would like to do that before the inquiry sessions, because I always find it's easier to understand the evidence if you've been out and you've seen the areas you're speaking about. There's nothing worse than listening to a lot of evidence and you can't visualise it. But at least if you go and seen the areas before the inquiry session, it just makes the evidence a lot more transparent and a lot easier for me to understand. So the areas that I thought I'd need to go and look at would be obviously Mr Lowe's land, and looking just where the A720 is and where the alignment is likely to be, just so I can visualise that better than just on the plans that I've got at the moment. I'd also like to look at the location of the Suds Pond that's going to be in that area. Sheriffhall House, and also plot 107. I'd like to come and see that. Summerside House, plot 123. And again, the location of the Suds Ponds there. Summerside Cottage and Mr Nisbet's land holding, and the irrigation lagoon. I'd like to, I suppose, to get, I don't know how we do this, given it's Sheriffhall Roundabout, just a better understanding of the non-motorised user routes, that travel routes, and how that would kind of work. Just again, so I can visualise how that works and how far it extends in each location from the roundabout. It may be, and I'm just thinking about this further, that it may be worth going to some of the other statutory objector land holdings to look at some of the aspects of their objections, but again I could flag that, particularly on some of the plots where there's discussion about why the plots are required and what they're for, things like that, just again so I can see what's on the ground. There's various new accesses that would be constructed, and again it's quite useful to see where those would be in reality on the ground. Put a bit of context around the drawings, things like that. So that was my thoughts on the locations I'd want to go and see. Now, some of these also need access to third-party land, and it's whether Transport Scotland, I know in other inquiries you've facilitated the access or arranged that with objectors, so we can go on. I think most of it I probably need to be accompanied, so I know what's going where, not just using my judgment on the plans, but actually having people say, yeah, this is where the first drawings would be, or this is where the alignment is, or wherever it is. And it's just to get views, primarily from Transport Scotland, because it is your roundabout, how best to deal with that in the context of lots of traffic and cars using the roundabouts, and managing the number of objectors, because also we need to make sure it's safe. I can't have lots of people tripping around the roundabout and being unsafe. So really to get your views on how we can achieve that, because I think it would be useful, and also the timeline. I'm probably thinking a date maybe in November, before maybe December weather. November's not always great weather either, but I think that would help. So when documents and things are coming in December, the 20th of December, I've got a really good picture in my head of what things look like in reality.
Thank you, ma'am. First of all, in terms of the date, the promoter does think, well, certainly before the inquiry, but actually the sooner the better. Now, I don't know quite if that will be possible before the clocks change, but as it gets darker and the weather deteriorates further, we would be keen to avoid that. So if a date as soon as possible could be found, which suits everybody, that would be our preference. Insofar as visiting the roundabout, looking for locations on the side roads order, that sort of thing, absolutely the promoter will facilitate that. And you have, however, hit on one of the concerns about there being lots of people. The promoter would be keen to keep the numbers as low as possible for safety reasons, but recognising the number of parties who have an interest. So I don't quite know how we work around that. Maybe those who wish to attend, whether they could identify one number or one member of their number would be the way to deal with that.
Yeah, I mean, I agree. I've got to kind of keep people safe too. It's whether, if you're grouping together, one of you, at most two, would turn up for the site inspections. Again, it's not an opportunity for giving evidence. That's not the point of the site inspection. It's a factual thing for me. I may ask points of clarification on a site inspection, just so I totally understand what I'm looking at, where things are, but it is purely points of clarification. I would take things like drawings, things with me that I might write on. I might take photographs on site inspections for my own benefit. But again, it's not an opportunity to discuss the merits of the case at all. It's purely so I understand what I'm looking at. So when I hear the evidence, I can visualise what's going on. So whether you'd be happy that one of you, two of you at most, came along from the site-specific objectors, the statutory objectors, whether you'd be happy just to attend the site inspection on your bit of land, or whether you'd want to come along, be good to get a feel for that too. I mean, Mr. Lowe, I'm assuming you'd be quite happy just to come to your bit, your land. Yeah. Mr. Capaldi, you'd be happy just to attend the site inspection on your land, or would you want to come to the larger site inspection for other parts?
To be honest, I'd rather just concentrate on our property. Thank you.
And that's absolutely fine. Mr. Clan, how you feel, because you have raised some overarching issues, so would you like to come to the full site inspections, I would say, or are you happy just to restrict it to your site-specific issues on the basis that I'm not going to discuss the evidence at all? Okay, so based on that, it would be basically Transport Scotland, me, and one or two of your group, whoever that may be. Does that sound manageable? What I can do is I can go back and just check my availability on dates and get the case over to canvass round a couple of dates for the site inspection. It would be helpful if Transport Scotland could put an itinerary together. Again, to give third parties an idea of where we might be at their properties, so you're not waiting all day for us. That would probably be quite helpful, and how we'd manage that.
And, ma'am, the Transport Scotland will speak with the site-specific objectors who are not here and check their position. We've noted the ones that you're interested in, but perhaps in the note of meeting you'll just confirm if there are any others that you would like us to check. For example, the Buccleuch group of companies.
I will. I'll make it clear the objectors' land I'd want to go see in the note of the meeting. Obviously, you've heard my view of what I want to see. Is there anything else anyone thinks I should look at?
I think it would be worthwhile going to the Gilmerton Road overbridge. I think it's the A7. I think that's it's a good vantage point, and B, I think in one or two outline cases they've referred, I think it was the A7 urbanisation, that a cycle route is supposed to be going over that bridge, or at least it's going to be an arterial route into Edinburgh. So, but it's a good spot to take an overview of what's going on. And the other site, and I don't know how we get, well, I've been to it myself, but it's as you know, again, it's in the plans of a possibility of a link road coming off the Miller Hill junction into, I think it's called the Newton Farm site, and I think that's quite important. I know there's a cow tunnel there you can go through. I had to walk over fields to get to it, and I don't think you can get to it from the Dalkeith side. But it's just something to bear in mind that there is a proposal to put a link road in there on the Miller Hill junction and a park and ride. And if I mean, it's a hell of a trek, but it's just a suggestion.
I'm happy to trek. I don't mind.
Well, I'll not be there, but I'll say the Transport Scotland people will be happy to trek. So
bring the walking boots. I'm away from the 8th from the 4th till the 8th of November, but I'm sure I can defer to someone if there's available.
If we're trying to do it before the clocks go back, it might have to be that last week in October, but I just need to check my own availability for that week. But I'll bear that in mind, but I'll get the case officer to canvass dates first with Transport Scotland to make sure you guys are available, and then with others, and see if we can get a date. If it's not the last week in October, we'll have to drift into November, unfortunately.
Excuse me, I'm sorry to come back, and I don't know if you want to go into the Oakwood area of scientific interest, national importance, to listen to the noise, but again, I'll put that forward. It's a beautiful walk, it's a beautiful trek.
I kind of think with that, I'll confirm in the note of the meeting the locations, but that's helpful, thank you. Anything else?
I just wanted to read, the Gilmerton Road overbridge one is an excellent suggestion. It's the A772, just to be clear, it's not the A7. Yeah.
Okay, no, thank you.
Ma'am, the only final remark from Transport Scotland on that is we'll also, it will depend on numbers, but we will propose how to organise transportation. I understand that it would not be appropriate for the site visit at the roundabout to involve people crossing the carriageway, so one vehicle perhaps, if we can keep the numbers right down, even if it's an SUV or something, and take people safely from one side to the other and viewpoints. It has to be quite managed in order to be safe, but Transport Scotland can put forward proposals in that respect.
No, that's really appreciated. I totally understand we have to keep people safe. And if you've got any rules on like high vis, things like that, then can you let us know so people come to the site inspection? And if you can provide stuff people don't have it, or people can come prepared, so no one's in danger. Okay, so that's really helpful. Thank you for that. Again, we will check dates, but soon rather than later for that. So item 15, miscellaneous. This is just wrapping up bits and pieces. So core documents. Transport Scotland provides a draft list of core documents in its outline statement of case, which was really helpful. Now, for those who haven't been involved in the process, so core documents are those documents that are likely to be referred to by all parties. So it's to avoid everyone putting in the same document as a document. So we try and get a list of common documents that everyone may refer to with one number to keep it very, very simple. Otherwise, it's very unmanageable, and it's a waste of paper and everything else. We've got lots of documents we don't need. Your document lists and your inquiry statements will be the documents that you're relying on, your own set of documents, and Transport Scotland produce the overarching list that everyone can rely on. So Transport Scotland have produced a draft, and that's in their outline statement of case. Now, just a couple of points on that. We're kind of changing the way we're doing core documents just to make it more efficient from our case officer's perspective. So the first thing I'll ask is if you can number them CD 001.001 or CD 001.002 and so on. It goes on to our database a lot easier than CD 1 dot something. It's just the way our database is set up. And if it's not done in that way, they don't go on in the right order, and it causes a lot of admin time to sort them and put them in the right order. I'll set that out in the note of the meeting, but it's just a little admin thing that really, really helps our case officers no end. I'd also flag that we have now got core document libraries, which contain a range of documents that are commonly submitted, maybe not so much for this kind of case, but there might be certain local plans, things like that, which are in the core document library. And what we'd like parties to do now is, rather than submit a local plan, is just put the link in, and we can draw it down from the core document library. Again, it saves admin time in producing, emailing documents through and things like that. And we also have on the system already from Transport Scotland things like the orders, the environmental statement, and again, rather than submitting those documents again, what we'd like you to do is adding the hyperlink URL link into the core document list, which means we can just rename that document as part of a core document. And again, it's just an admin. I'll set it out in the note of the meeting because it's a slight change, but it just means our case officers can manage the volume of documents a lot quicker and a lot easier and without duplications. It's all about efficiency from our perspective. If you're referring to any of our decisions, which you might not in this case, but if you're referring to anything, again, a hyperlink is sufficient. You'd have to produce the document. But I'll set that out in the note of the meeting, and we might provide links to help you find the libraries, things like that. But what I would ask is that Transport Scotland, you can liaise with other parties to pull that list together, so it's a comprehensive core document list. That would be really useful. For documents that aren't in the list or haven't been submitted so far, then they would be submitted digitally by Transport Scotland, just in the usual way, and we can set up a workspace in Objective Connect, if that's easier to upload documents, which I think we've done previously with Transport Scotland, which again, it's just an admin process. It makes it a lot easier for our case officers to manage the workload. But I will set that out so it's very, very clear. So if Transport Scotland could take the lead on that core document list, that would be really useful. As I said, other parties, you can submit the documents you're going to rely on. That's absolutely fine. It's just the common documents, it's more efficient in this core document list. Now we're out of the COVID restrictions, all documents must be placed on deposit. We're back into that world again. We've been doing that for a long time. What that means is that we need to put the documents in a public place somewhere, so that members of the public, anyone, can go and look at them. And normally it's the promoter that does that, and they'd have to collate to make sure that all the documents there, all the statements there, all the witness statements there, everything that performs part of the inquiry becomes part of this public set of documents. Now, previously, I know Transport Scotland have done it as a laptop in a library, and it cuts down on paper. Would that be what you propose to do this time, rather than a hard set of documents?
Yes, ma'am, that would be our strong preference. It just saves a great deal of paper, and libraries never seem to be particularly happy about the amount of space that is taken up. So if a laptop could be provided, understand that it should be okay to use Dalkeith Library.
I can understand a library not wanting boxes and boxes and boxes of documents. And I think it's easier nowadays for people to have documents on a laptop, particularly if you want to have a search function. It's way easier to do that than piling through a load of documents. I'm happy with a laptop, and Dalkeith Library seems a good place. So if you can organise that. So make sure, obviously, when you're submitting your statements, your documents, your witness statements, you send them to our case officer, but you also copy in Transport Scotland and the other parties in the sessions. But again, I'll make that clear from the note. And I'm assuming everyone's happy that we do things electronically. No one's got any issues with that. I would say, from my perspective, if it's probably more applicable to Transport Scotland, maybe Mr Lowe, actually, if you're producing any more drawings or plans, I would quite like hard copies of those at the right size, as opposed to me printing an A4 off. It's just easier to get for me to look at them if they're the proper size. All documents that are produced will be put on our website. We do have rules about redacting, but generally everything goes on the website, and it's open for public inspection on our website as well as in the library. If you've got any queries about anything, then please contact the case officer, who you've probably all been in contact with, Jane Anderson. I'll put her details again in the note of the meeting so you've got them, but she's the first point of call. Feel free to email her if you've got any issues, any concerns, any queries you're not sure, but hopefully the note of the meeting will set everything out and that'll be clear for you. It will include all the dates we discussed, as I say, the contact details, the processes, so it's a real good guide for you, so it's a good thing to have to hand going forward, because it does contain everything you probably need to know going forward in the process. Everyone who's here today will get a copy of that from Jane. Again, it goes on our website, so you can always find it there too, but you will get emailed a copy of it. So that takes me to the last item, which any other relevant matters, if there's anything anyone wants to raise. So I'll start with Transport Scotland, and I'll work around the table if there's anything that has come up that I haven't covered.
No, ma'am, nothing else to add. Thank you very much for convening this meeting.
No, nothing to add, and thank you for your chairing.
Nothing else to add.
It was good. We had a meeting with Transport Scotland and ACOM just a few weeks ago, and that was really the first proper sit-down we've had with Transport Scotland since the public inquiry, the public exhibition rather. And I found it very fruitful, and I thought everyone was very helpful. I got a note from them just dated the 30th, subsequent to the meeting we had earlier on, and it said that they remain committed to trying to resolve the objections, which is fantastic, and we'd be happy to engage with them, ideally in advance of the pre-inquiry meeting. Well, this is the 4th. That was the 30th. There was not really much time for us to communicate at that level. So I appreciate the offer, and we'll hopefully get something moving. But I just felt it was maybe a bit we are trying to communicate, having had 2.5 years of no communication, so it's a step in the right direction, but I just thought I'd mention it in passing.
I guess the only point I'd make is that even though we're in this process now, there's nothing to stop you continuing those discussions with Transport Scotland. And if it gets to the point you can withdraw your objection, great, you withdraw your objection. There's nothing to stop that happening. Even if it's the day before the inquiry, I don't mind, withdraw your objection if you're happy with the resolution you've got with Transport Scotland. Just because we've started this doesn't mean you can't reach agreement. This is just to kind of expedite matters, so at some point ministers have got to have a report on the orders, decide what to do with them. So I hear what you're saying about timing. I would encourage all parties to keep discussing with Transport Scotland if there's things, even if there's 2 or 3 things you can reach agreement on. Again, it just narrows the scope of the inquiry, so I would encourage people to still engage with Transport Scotland and Transport Scotland to still engage with objectors, even though we're on this process now. But I hear what you're saying. Thank you.
I'm very happy with what I've heard tonight, and thank you very much.
I have no comment.
No further matters, thank you.
No further matters, and thank you very much.
Okay, well, thank you very much, and thanks for your time tonight. I know it was late, but thank you for coming along. It's been really helpful to me, and I think we've got everything kind of agreed in the way forward, which is good. So just safe journey home, everyone, and we'll be in touch probably in the next few days with a note of the meeting. Thank you.